court proceedings. The parties are present, and both parties are in pro se or in pro per, which means they represent themselves. Regarding these types of files, the court tries to make this as simple as possible for each of the parties as we move forward. I'll be asking questions. If there's anything you don't understand, please let me know and we'll proceed accordingly. We always begin with the plaintiff first, but I'm going to swear in both parties. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I'll begin with the plaintiff. This is your name, Tricia Lee Choi.
Yes.
And you are the plaintiff in this matter, correct?
Yes.
Have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days, immediately preceding your filing this complaint for divorce? At the time you filed this complaint for divorce, was your husband, Mr. Choi, also a resident of Huron County?
Yes.
Is it true that you were married on May 15, 2019 in Sandusky, Michigan by a person authorized to perform marriages in this state?
Yes.
And is it, well, according to your complaint, you were still living together as husband and wife. Is that still the case?
We live together. Yes.
Very well. And prior to the marriage, your last name was Pringle, P-R-I-N-G-L-E. Your husband has always been known as Jonathan Choi. Is that correct?
Correct.
There is one minor child, correct?
Correct.
And we won't use names, we use initials. The child's initials would be AMC, correct?
Correct.
Is AMC now 6 or is AMC 5?
She's 5.
She's 5 still, okay. I have to ask, are you currently expecting?
No.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes.
Still true today?
Yes.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
First, not long anymore.
Very well. Is there any chance of reconciliation?
No, sir.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with Mr. Choi?
No, sir.
Thank you. There is a proposed judgment that has been submitted to the court, and it indicates to the court, and this may be incorrect because I think this is different than the temporary order, but I could be wrong. It indicates in your proposed judgment that legal custody would be awarded to you solely, but physical custody to both parties.
Yes.
That is correct?
Yeah. Yes.
Okay. So, do you understand what legal custody is?
Legal is the one where I make the decisions about doctor's appointments, schooling.
Religion, education, exactly. And that is your understanding then, that you would have sole legal custody?
Yes, sir.
But physical custody would be awarded to both of you jointly?
Yes, sir.
Okay. What is the parenting time arrangement?
It's summers with him and the rest with me.
Okay. I have to ask this, but let's say it's summertime, we go through this judgment, and you're out of state, you're on a conference or you're on a trip. AMC requires medical treatment. AMC has to go to a local hospital. The local hospital says, you don't have legal custody, Dad. We need to have mom come in and sign off to make sure we can proceed.
Okay, then it's supposed to be joint on both. I think we did actually adjust that when we came in.
Okay, and I don't want to change something that you've agreed to, but I just wanted to pose that to you because
Yeah.
in the
you're
event,
correct.
let me take a look here. Why I remember this did go to facilitation too, did it not?
Yes.
By the way, I both appreciate you attending the SMILE program as well. Okay, now, the addendum to the interim support, the interim order regarding custody indicates that both parties would have joint legal custody of AMC, but you would have sole physical.
Yes. Okay.
So, changing your mind regarding.
No. That's what I wanted. Yes.
You want sole legal, or I'm sorry, sole physical or primary physical, so to speak.
Yes.
But joint legal for both parties.
Yes.
We okay with that, Mr. Choi? Okay, and I'll get to that question with you in just a moment to place it on the record. So I'll make that change. All right, and do you believe that custody arrangement is in the best interest of AMC?
Yes.
Thank you. And you stated regarding parenting time, the proposed judgment indicates that parenting time arrangements will be made by mutual agreement of the parties. What if you don't agree?
Then we will default to Michigan guidelines.
The Huron County Parenting Time Guidelines from 20. Newest one?
Well, the current guidelines are the 2022 version, and we don't have a set schedule. However, my understanding is that there's an intention to move out of state, and I believe the parties would want the long distance out as a backup.
I see.
Yes.
That makes sense.
Yes.
Okay. So by mutual agreement of the parties, however, if that does not work as a backup, then you wish to have a long-term policy.
Yes.
Okay. That also 22 insurance? The long-term policy.
It's not, because it's not outlined in the 22 policy. It is defined in the 2016, but if the court just wishes to reference the long distance policy, we can provide that schedule.
Thank you. And you believe that parenting time arrangement is in the best interest of AMC?
Yes, sir.
Right, thank you. And you're aware that a party with physical custody has to notify the friend of the court whenever there's a change of address?
Yes, sir.
But the domicile of the minor child shall not be removed from the state of Michigan without prior approval of the court.
Yes.
Now, obviously, if there's summer parenting time out of state, for instance, under that schedule, still domicile still here within the state of Michigan.
Yes.
So is it true then that you agree that either party may move more than 100 miles from where the party lived when the case was filed, as long as they still live in the state? Well, no, that's not going to apply. Was there discussion regarding child support?
Yes, sir.
And what is your understanding regarding child support?
He is paying the medical.
So what we're talking about then is when you say by pay the medical,
Because she's on, the child is on Medicaid. So,
okay. Mr. Schultz? It's acceptable.
That is what's currently ordered on an interim basis at $14 per month, Your Honor.
14, okay.
Yep, and that was a deviation from the Michigan Child Support Formula, which was a total of $725 per month, based on the party stipulation that it's in child.
Very well, thank you. And was there anything discussed regarding income tax deductions?
yes, sir.
And what is your understanding regarding that?
He is claiming her every year.
Every year? All right. Proposed judgment, great. However, there'd be the standard medical provision, correct? Is it true that neither party is awarded spousal support and that issue is forever barred?
Correct.
Thank you. Are there any pension, annuity, or retirement accounts?
He has a retirement account.
And what is your understanding regarding what will happen to that account?
He keeps it.
He keeps it? There is real property, land, correct?
Yes, sir.
And who's awarded the marital home?
It's in his name, so he's keeping it.
Okay. And that begins with the house number 331, correct?
Yes, sir.
And you shall sign a quick claim deed to, within 30 days of entry, the judgment for the benefit of the defendant, correct?
Yes, sir.
Is there any mortgage currently on the property?
Yes, sir.
Is it both names?
The mortgage is not.
Solely in his name?
Yes, sir.
Okay. So obviously he'd be solely responsible for the mortgage, insurance, taxes, liens, and any other costs associated with the property.
Yes, sir.
Thank you. Obviously, personal property has been acquired during the marriage, correct?
Yes, sir.
Has it already been divided?
Yes, sir.
Is there any property that you may hold of his or he may hold of yours that needs to be exchanged?
No, sir.
And you understand whoever currently then possesses the property or has the property in their possession, if there's any debt on that property, the person keeping the property is solely responsible for the debt, indemnifying and holding harmless the other party therefrom, correct?
Yes.
Okay. If either party possesses any life insurance that carries cash value, each party would hold that policy free and clear from any claim to the other.
Yes.
You wish to have your previous name restored?
No, sir.
Ms. Choi, are there any other assets or any other debts that we've not covered?
No, sir.
Very well, thank you. Sir, would you please state your name for the record?
Jonathan Choi.
Mr. Choi, did you hear the questions and the answers that were provided this morning regarding this file?
Yep.
Regarding the minor child, regarding the real property, regarding the personal property, and all other terms regarding the agreement. Is that your understanding of the agreement is well reached between you and your spouse?
Yep.
And are there any other assets or any other debts that you're aware of that we've not covered?
No.
The court outlined on the record through questioning and answering as well by your spouse, the custodial arrangement and the parenting time or custodial time. It would be really parenting time. Do you agree with that?
Yes.
And you believe it's in AMC's best interest?
Yes.
Anyone force you or threaten you into this arrangement?
No.
Is this by mutual agreement between you and your spouse?
Yes.
Are you asking the court to adopt this judgment?
Yes.
Thank you. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, judgment of absolute divorce is granted to the plaintiff, Tricia Lee Choi, from the defendant, Jonathan Choi. Regarding AMC, the parties shall have joint legal custody. Mother shall have sole physical custody. The court finds that this arrangement is in the best interest of the minor child. Neither party shall remove the domicile of the minor child from the state of Michigan without prior approval of the court. Each party is obligated to keep the friend of the court notified of any change of address or employment. Father shall pay support through the friend of the court as a deviation to the plaintiff in the amount of $14 per month. Father is awarded parenting time as outlined on the record. Neither party is awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning pensions, tax exemptions, and life insurance. Plus, a standard medical insurance provision will be provided. The court has reviewed the proposed judgment of this case, and before the court executes it, the court will have the friend of the court review it. That's why Ms. Schultz is in the courtroom this morning. And once it is reviewed, she will sign off on it. The court will then sign off on it. And I'm hopeful that we can get this done here before the end of the morning. You'll be able to get copies of your judgments today. And that will be all, except for the simple fact is, and I mentioned this in the previous file, and I mentioned in every file, you're going your separate ways, obviously, but you have a common interest here. And AMC is number one. And whatever differences you have, keep those separate. Because AMC, as a 5-year-old, is looking to both of you. And AMC, I guarantee, is a sponge that's soaking up all that information, and she's learning from both of you. And if you continue the front that you have, and that's not a front, the arrangement you have regarding being able to speak with each other, being able to make decisions in the best interest of AMC, she's going to go a heck of a long way, just like both of you. So I wish you both the very best.
Oh, you're about to give in this
That'll be
case
all.
is the truth, the whole truth, nothing but the truth, so help you God.
Ms. Salem, you appear on behalf of the defendant in this case, and I believe there was a counter complaint as well, correct?
There is not, Your
No?
Honor.
Okay, I'm mistaken.
However, I did meet with the parties, a settlement has been reached, a judgment has been typed up, and the parties have signed it. The plaintiff has indicated that he has no objection if I examine him so that we can put the proofs on the record.
Sounds great. Thank you. You may proceed.
Thank you, Your Honor. Mr. Smith, would you state your name and address for the record? And you are the plaintiff in this action for divorce?
Yes.
You've alleged in the complaint that you lived in the county of Huron for at least 10 days in the state of Michigan for at least 180 days immediately prior to the filing of the complaint. Is that correct?
Correct.
You've alleged in the complaint that you and the defendant were married on August 5th, 2006 in Kalamazoo County, Michigan. Is that correct?
Correct.
That you and the defendant separated on or about September 1st, 2023. Is that correct?
Correct.
You've alleged in the complaint that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time the complaint was filed?
Correct.
Is that true today? Are you willing to resume a husband and wife relationship?
No.
Can you briefly tell the court in your own words why you feel that is true?
There's been an unresolved breakdown in the relationship with one couple.
And there are 3 children of the marriage. Is that correct?
Correct.
And that is GGS, BJS, and RMS. Is that correct?
Correct.
And to the best of your knowledge, is the defendant pregnant?
No.
We have been able to reach a settlement in this matter. Is that correct?
Correct.
And according to the settlement that has been reached, you and the defendant would have joint legal and joint physical custody of the 3 minor children. Is that correct?
Yes.
That the domicile of the minor children would not be removed from the state of Michigan or more than 100 miles without prior approval of the court. Is that correct?
Correct.
And that you and the defendant would have parent or custodial time year-round. You would have the minor children on Wednesday after school or noon if there's no school until Saturday at 2 p.m. The defendant would have Saturday afternoon until Wednesday when the children are taken to school or noon if there's no school. And you would alternate Saturdays from 2 p.m. until Sunday afternoon. Is that correct?
Correct.
Do you believe the custodial arrangement is in the best interest of the minor children?
Yes.
Now, you asking the court to order the same?
Yes.
And we have attached to the proposed judgment the standard holiday schedule that has been marked as Exhibit A. And you are asking that to be incorporated into the judgment of divorce, is that correct?
Correct.
We have included in the proposed judgment the standard reasonable talk time provision, that each of you would have talk time with the minor children as agreed to between the parties. If you're unable to agree, then it would be on Tuesdays and Thursdays at 7 p.m. And that would include telephone calls, text messages, video conferencing, including Skype, FaceTime, and other similar applications. Is that correct? And that the parties may use app closed co-parenting application for purposes of non-emergency communication regarding the minor children. Is that correct?
Correct.
That neither of you would speak negatively or in a degrading manner regarding the other party or your family and household members, and you would prevent your family and household members from speaking negatively or in a degrading manner regarding the other party as well. That would include verbal comments, text messages, and social media posts. Is that correct?
Correct.
And that any communication would be between the two of you, and you would avoid using the children as a go-between. Is that correct? That you would continue to pay child support to the defendant through the friend of the court in the amount of $213 per month for 3 children, $172 for 2 children, and $117 for 1 child. Is that correct?
Correct.
That you and the defendant have also agreed that you would divide equally the adoption subsidy. Is that correct? And that the plaintiff, you, shall receive a child support credit of $986. Is that correct? We have included in the proposed judgment the standard support or urge provision, retroactive modification provision, statutory oversight provision. Is that correct? That each of you would obtain and maintain health insurance on the minor children if it's available to you through your place of employment at a reasonable cost. Is that correct? That all medical insurance would be forwarded to the friend of the court's office and processed in the ordinary course of their business. Is that correct? With respect to tax exemptions, each of you would be allowed to claim one of the minor children for tax purposes. You would claim the third child in the even number tax years, and the defendant would claim the child in the odd number tax years. When there are only two children available, each of you would be allowed to claim one of the children. And when there's only one child available for tax purposes, you would alternate that child on a year-to-year basis. You would claim that child in the even number tax years, and the defendant would claim the child in the odd number tax years. Is that correct?
Correct.
Neither you nor the defendant would be entitled to any spousal support, and the issue is forever barred. Is that correct?
Correct.
That each of you are awarded your life insurance policies free and clear from any claim by the other. Is that correct?
Correct.
And that that any interest or right that you have to any pension or retirement plans of the defendant, whether vested or unvested, accumulated or contingent, are extinguished, and the defendant shall hold her pension and retirement plans free and clear from any claim by you. Is that correct? And that any interest the defendant has to your 403B plan is extinguished, and you shall hold your 403 plan free and clear from any claim by the defendant. Is that correct?
Correct.
With respect to your pension, the defendant is awarded an interest in your defined benefit retirement plan with the Office of Retirement Services, the Michigan Public School Employees Retirement System, and an EDRA would be entered awarding the defendant a 50% interest in your plan that has accrued as of August 16, 2024. And we have included the terms of that proposed EDRA in the judgment of divorce. Is that correct?
Correct.
That you and the defendant would be equally responsible for the cost of the preparation of that EDRA. Is that correct?
Correct.
With respect to personal property, you are awarded as your sole and separate property, free and clear from any claim by the defendant, all personal property presently in your possession, including the 2014 Ford F-150 pickup, the 1994 Chevy pickup, the 1972 Nomad camper, the 1986 Sprite, and the 2004 Honda motorcycle. Is that correct?
Correct.
You would assume the debt on the property awarded to you and hold the defendant harmless therefrom. Is that correct?
Correct.
That the defendant is awarded all personal property presently in her possession, including the 2022 Ford Explorer. She would assume the debt on the property awarded to her and hold you harmless therefrom. Is that correct? That with respect to the marital home, you are awarded the marital home free and clear from any claims by the defendant. Is that correct?
Correct.
That you shall pay to the defendant the sum of $36,570 for her equity in that home, and that shall be paid within 1 year from the entry of this judgment of divorce. Is that correct? That in the event said sum is not paid within 1 year from the entry of the judgment, interest shall accrue at the statutory interest rate retroactive to the date of judgment, and execution shall issue forthwith. Is that correct?
Correct.
However, you are to assume the debt, the mortgage on the home, and refinance the same to remove the defendant's name within 90 days. Is that correct? Correct. In the event you are unable to refinance the mortgage to remove the defendant's name or pay the defendant as provided in the judgment of divorce, then the marital home would immediately be placed for sale at a mutually agreed to price with a mutually agreed to realtor. Upon the sale of the home and the payment of its closing expenses, including the mortgage, the defendant would receive the first $36,570, and you shall receive the remaining proceeds. Is that correct?
Correct.
Each of you would accept any reasonable offer, and either of you could petition the court for a court order of sale at any time. Is that correct?
Yes.
That each of you will assume and pay as your sole and individual obligation any debt you've incurred in your individual capacity since the filing of the complaint, and hold the other harmless therefrom. Is that correct? And
I'm sorry, I didn't.
Yes.
Thank you.
Sorry.
And there aren't any joint debts other than this mortgage. Is that correct?
Correct.
And we have included in the proposed judgment the standard conveyance provision, mutual bankruptcy clause, disclosure of assets provision, bar to all claims, release and satisfaction provision, enforcement expense provision, attorney-client clause, independent advice of counsel, and tax advice provision. Is that correct?
Yes.
Mr. Smith, are there any other assets or any other debts that have not been provided for?
No.
Are you satisfied with the settlement that has been reached?
Yes.
Your Honor, I have no further questions of the plaintiff.
Thank you, Ms. Salins. Before we proceed to your client, did I hear correctly the support amount is $213 or $200?
It is $213 per month for 3 children, $172 for 2.
Thank you. You may proceed.
Thank you. Your Honor, at this time, I would call my client to testify.
You-
Ms. Smith, please state your name and address for the record.
Katie Lynn Smith.
And you have heard the settlement placed on the record this morning?
Yes.
Is that your understanding of the settlement that has been reached?
Yes.
Are there any other assets or any other debts that have not been provided for?
No.
Are you satisfied with that settlement?
Yes.
With respect to the custodial provisions, do you believe the custodial arrangement is in the best interest of the minor children?
Yes.
Are you asking the court to order the same?
Yes.
Are you currently pregnant?
No.
Are you asking this court to restore your prior name?
No.
And are you satisfied with my representation?
Yes.
Your Honor, I have no further questions of the witness.
Thank you, Ms. Salins. Based upon the testimony presented, the court finds that the statutory grounds for divorce are established. Therefore, judgment of absolute divorce is granted to the plaintiff, George Gregory Smith IV, the defendant, Katie Lynn Smith. Regarding GGS, BJS, and RMS, the parties shall have joint legal and joint physical custody. The court finds that this arrangement is in the best interest of the minor children. Either party shall remove the domicile of the minor children from the state of Michigan without prior approval of the court. Each party is obligated to keep the friend of the court notified of any change of address or employment. Fathers shall pay support through the friend of the court to the defendant at the rate of $213 per month with statutory oversight fee. That's for 3 children. Parties are awarded custodial time as outlined on the record. Neither party is awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning pensions, tax exemptions, life insurance, and the standard medical insurance provision with the uninsured medical expense divided pursuant to the percentage stated in the uniform support order. The court has executed the judgment that has been presented as well as the support order that has been provided. It comports with the testimony presented. And I wish to thank both parties for being able to agree. Most importantly, and I say this in every case, and when it comes to G, B, and R, each of you are going your separate ways. But there's a common bond between the 2 of you regarding those 3 very important individuals. So whatever your differences are, please keep those separate and away from the children because they look to both of you for guidance and support. And by doing so, they'll be just as successful as each of you are. Ms. Smith, make sure you thank your attorney for her hard work as well in putting all this together. I wish you both the best. Time and date set for divorce proceedings. Ms. Myers is present. She's in pro se. Court calls Benjamin Santos Myers Sr. No response. It's currently 9:37. He's not checked in via Zoom, according to my review of his name screen. The defendant had a default entered against him in this matter back on October 4, 2024, signed by Ms. Lori S. Neal, Huron County Clerk. A certificate of mailing is provided from the same day from the clerk's office as well. So we will proceed under a default basis. Ms. Myers, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Miss, would you please state your name for the record?
Ashley Myers.
And you are the plaintiff in this matter, correct? And have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes.
At the time you filed this complaint for divorce, was Mr. Myers residing in Huron County or was he residing in the state of Florida?
We were visiting in Florida, and then I'm the only one that came back.
All right, so he was in Florida then at the time. And is it true you were married on December 6, 2019 in Bad Axe, Michigan by a person authorized to perform marriages in this state?
Yes.
You stopped living together as husband and wife on or about March 14 of last year, is that correct? And prior to the marriage, your last name was Brooks, Brooks.
Yes.
Your husband has always been known as Benjamin Santos Myers Sr., correct? There is one minor, well, actually, there are 4 minor children, is that correct?
Yes, sir.
Their initials are JMM, BSM, PLM, and SPM.
Yes.
How old is JMM?
She's 10,
10. BSM,
9,
PLM,
7,
SPM.
4.
I have to ask, are you currently expecting?
No.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that marriage could be preserved. Was that true at the time you filed the complaint?
Yes.
Still true today?
Yes, sir.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
Just a breakdown of the marriage.
Very well. Is there any chance of reconciliation?
Never.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with the defendant?
Absolutely not.
Very well. According to your proposed judgment of divorce, it indicates that you would be awarded sole legal and sole physical custody of your 4 minor children. Is that correct? And do you believe that's in the best interest of all 4 children?
Yes, sir.
And you are required to notify the friend of the court in writing whenever the address of the children changes, correct? And that domicile of the minor children may not be removed from the state of Michigan without prior approval of the court. Is that correct?
Yes, sir.
And pursuant to statute, the statute does not apply because you are granted sole legal custody of the party's minor children, correct? The proposed judgment indicates that father will not have any parenting time. Is that correct?
Correct.
Is this what he agreed to? Is that a yes?
Yes, sir.
Neither party would be awarded spousal support if the issue is forever barred, correct?
Correct.
Was there a support calculation done in this matter?
Yes, sir.
And what do you believe the support amount to be?
402 a month for all 4 kids.
Payable to you from the defendant?
Yes, sir.
Okay. Is that the temporary amount that was awarded previously?
Yes, sir.
What is your understanding regarding claiming the minor children for tax purposes?
I claim them every year.
Standard medical insurance provision would be provided, correct?
Yes, sir.
Do either parties have pension, annuity, or retirement accounts?
No, sir.
You own any land?
No, sir.
No homes?
No, sir.
How about personal property?
No, sir.
There was no personal property acquired during the marriage? Nothing?
No, sir.
So is it fair to say then, whatever property you currently have in your possession, you would hold free and clear from any claim of the defendant, and the same for him?
Yes, sir.
If there's any debt associated with the property, whoever receives it is solely responsible to pay for that debt, and you shall indemnify and hold the other party harmless from that. Correct?
Yes, sir.
standard life insurance provision as well, correct?
Yes, sir.
And you wish to have Brooks restored as your surname?
Yes, sir.
Are you aware of any other marital assets or debts that we've not addressed?
No, sir.
Court finds that statutory grounds for divorce have been established, therefore a judgment of absolute divorce is granted to the plaintiff Ashley Marie Myers for the defendant Benjamin Santos Myers. Regarding J, B, P, and S, plaintiff shall have sole legal and sole physical custody of the minor child. Court finds that based upon the testimony that is in the best interest of all 4 children. Domicile of the minor children shall not be removed from the state of Michigan without prior approval of the court. Each party is obligated to keep the friend of the court notified of any change of address or employment. Father shall pay support through the friend of the court plaintiff at the rate of $402 per month, plus statutory oversight fee. Father is not awarded any parenting time. Neither party is awarded spousal support. The divorce judgment shall include the property division outlined on the record, as well as any and all provisions concerning pensions, tax exemptions, and life insurance. Standard medical insurance provision will be provided with the uninsured medical expense divided pursuant to the percentage stated in the uniform support order. And finally, the plaintiff is restored the surname of Brooks, B-R-O-O-K-S. Ms. Brooks, what will happen next is Ms. Schultz will review the judgment that has been presented. And once that is reviewed and okayed through the front of the court will execute the document as well as the support order. You'll be able to get copies of that. So if you don't mind sticking around for a little bit this morning, we should be able to get that accomplished. If not, then the court will mail it to you at your residence, which is held confidential, but it's in the court. Do you have any questions?
Yes, sir.
Would you like to? Awesome. 8:01 p.m. Time of day session proceedings. The parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. The court has been advised that the parties have reached a settlement in this matter. Is that correct? Yes, Miss?
Yes.
Okay, thank you. I'll be asking you some questions, and then at the end of this, there's a judgment of divorce form that will need to be completely prepared. I will try to fill in the spots that I'll be asking questions on, but the rest, each of you will have to prepare, one of you will have to prepare that. Ms. Schultz will review it, and then hopefully we can get all this rolling today. So I'll begin with the plaintiff. Sir, would you please state your name and spell your last name for the record?
Brandon Kozefka, Kozfkay.
And you're the plaintiff in this matter, correct? Have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes, sir.
At the time you filed this complaint for divorce, was Ms. Kozefka also a resident of Huron County?
Yes, sir.
Is it true that you were married on August 21, 2021 in Sanilac County, Michigan by a person authorized to perform marriages in our state?
Yes, sir.
You stopped living together as husband and wife last year on July 10th, on or about. Is that correct?
Yes, sir.
Prior to the marriage, your spouse's last name was Bowers, B-O-W-E-R-S. Is that not correct?
No.
What was the last name?
Probst, P-R-O-B-S-T.
P-R-O-B-S-T?
Correct.
Yeah.
I see. Gotcha. Okay. One minor child in this marriage, correct?
Yes, sir.
CSK?
Yes, sir.
How old CSK?
7.
7? As far as you know, is your spouse currently expecting?
No.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved. Was it true at the time you filed the complaint?
Yes,
Is
sir.
it still true today?
Yes, sir.
Briefly, can you state to the court why you feel the marriage cannot be preserved?
No common ground.
Very well. Any chance of reconciliation?
No, sir.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with the defendant? Thank you. All right, so is there an agreement regarding custody of CSK?
Yes.
And what is that to your understanding?
Well, what we have.
There's
right now-
physical custody and legal custody.
Okay.
Let's begin with legal custody. You understand what legal custody is?
Is that,
You weren't listening in the previous hearing.
I caught on to it, it slipped my mind.
I'm kidding you.
Um,
I'll help you out.
thank you. I appreciate
Very important decisions regarding your child, religion,
Absolutely.
education, medical, that sort of thing. You understand that? Okay. What is your understanding then regarding who or whom may have legal custody of your child? Is it both of you?
Yes, sir.
Okay, so be joint legal custody. Is that correct?
Yep.
I'm not trying to put words in your mouth, but is that how you understand it to be?
Yes.
Okay. Let's talk about physical custody. Obviously, that's the easier one. That is where the child primarily will reside. And even though parties may have one more days on one side or the other, it still can be joint physical. But is it joint physical custody? Do you have primary physical custody? Does she have primary physical custody? What do you believe it to be?
Well, I believe I do.
You would have physical custody? Okay.
I believe I have more. Where?
Oh, we're okay. Miss, is that your understanding? No.
We haven't received, it's been split.
Okay. So when I say primarily reside, for instance, in the last case, the individual that was before the court, one party resided in Florida, other party resides here, and the child is going to be here, and that other party in Florida doesn't even have visitation or any parenting time. So that would make sense for sole physical or primary physical.
Okay, yeah.
So what is it then as you understand? Would it be joint physical?
Yes, we both, yes.
Okay. And again, I'm not trying to put words in your mouth or twist your arm. I want to make sure that we're all on the same page. Okay. And do you agree that where the child resides, whether it's, let's see, check here. You're on the east side and you're in the center area, correct? I call it center.
Yeah, I live in Kindy.
I wasn't gonna say that, but I'm just trying to keep the towns out of it, but,
I don't know it, I don't know that much around here, so, yeah.
okay. All right, so bottom line is, that's known as domicile, where the child will live. And it sounds like domicile will be obviously Huron County, your city, or I'll just use it that way, and your village, your area. And as a result of that, the minor child shall not be removed. And I'm not talking vacations. I'm talking shall not be removed from the state of Michigan nor more than 100 miles from the child's current residence without prior approval of court. Is that what you understand to be, sir?
Yes, sir.
Okay. Okay, this will be the one we need to hammer out. What is what I call the custodial time or parenting time regarding your child? How have you been doing it so far?
So far he's with me for school days. And then on the weekends, she's been taking him. Usually one day during the week, he'll go over there as well.
Okay, so what about summer?
Well, we discussed week on, week off in summer.
Okay. So as I understand it then, and it's every weekend with mom?
3 out of the 4 in a month, yes.
Okay. So the custodial arrangement would be during the school year, and the child's how old again?
7.
7. So during the school year, you would have, well, mother would have her time 3 weekends a month during the school year. Is it Friday through Sunday or Friday through Monday? Thursday through Monday?
It's usually Friday through Monday, but there has been times where if we didn't have school Friday, she would get them Thursday, yes.
Okay. But at least Friday after school to Monday morning?
If she doesn't have to work, then she takes them to work or to school, but if not, then it's Sunday evening. Yes.
Oh, it's Sunday evening otherwise?
Yes.
All right, and I'll get to the, obviously, I'm trying to come up with a schedule here, so in the event you don't agree, we have something as a default, but it primarily, it sounds like it's the parties mutually agree.
Absolutely.
Okay, but in the event you don't agree, it would be 3 weekends a month, Fridays after school through Sunday evening, 6 p.m. What time do you usually exchange a child?
6, 7, yeah, around that.
Okay. During the summer, it would be week on, week off, correct?
Yes.
And what is the exchange date? If you cannot agree, would it be Friday? Would it be Sunday?
Sunday to Sunday.
Sunday? Sunday to Sunday? 7 p.m.?
That works, yes.
Okay. Sunday at 7 to Sunday at 7. And when the school year ends, who begins their week first? Mother or father?
I guess, do you get the other two?
It would be, because it always falls right on Father's Day weekend. Normally, it's like that's when, right around there is when the end of the school year is.
So the summer parenting time schedule will begin with Dad.
Yeah.
Okay. Now, obviously, you can have whatever schedule you wish to as mutually agreed.
Mhm.
Say yes.
Yes, sir.
Okay. And do you also agree that in the event you cannot agree on holidays, that would be the 2016? 22. See, I'm learning every day. The 2022 holiday schedule in the event you don't agree.
Okay.
Is that any problem with that?
No, sir, sounds good.
One is be designated parent A, parent B, but
Dad is parent B, mom is parent A.
mom is parent A. Got it. Now, like I said, if you both mutually agree on something different, that's great. What we're trying to avoid is, well, I want the child on Christmas Day. And then all of a sudden, the other parent says, no, it's my time. And then you're burning up the phone in front of the court. And then we have to battle it out. If we can have at least a backup, this will help in the long run. I'm hoping that'll never happen. It sounds like both of you are able to work together with the best interest of CSK, but we always want to have a fallback provision.
Yes, sir. That's what it's about, is the best interest for him.
I appreciate that. Have you discussed child support?
Yes, sir. We both agree that we don't think neither of us needs to pay it.
Okay, is there any public assistance involved?
Not that I'm aware of, no.
He used to get state insurance, but he doesn't anymore. He gets it through my work.
Ms. Schultz?
That is accurate for friend of the court records. There are other benefits, but those benefits do not require participation.
Great. But there's still ordinary medical.
That would be up to parties if they're deviating. The friend of the court had done a full investigation, which addressed custody, parenting time, and investigation. That is still pending objection period as of today. So there would, depending on what the final parenting time schedule is, what I've heard so far is a discussion about what's been included in the interim order for the school year. And based on that schedule, mom was recommended to be the payer at $419 per month, but that did not include week to week during the summer because the summer schedule wasn't addressed. So because there is no Medicaid, the parties can set medical support at 0 as well. There's no redirection.
Great. Is that what you wish to do?
Yes, sir.
Okay. Now, I just heard a moment ago that the friend of the court is the recommendation complete provided to the parties? We're still in the objection.
It's completed, it has been issued, but it is still in the 21-day injunction.
Okay. Have you reviewed the recommendations from the friend of the court regarding custody and parenting time?
Yes, sir.
And is that the plan you wish to move forward with, or is it the plan we're talking about now?
What we're talking about now, I like, the only thing I didn't like in the packet was the custody or child support. I don't see a need for that.
Okay, and parties can deviate, but because we may be able to make this a little bit more simple, I'm assuming the recommendation spells everything out pretty well.
So the recommendation based on for parenting time has a different result for child support because the schedule that's been discussed so far is not what was recommended. And that the support was recommended for dad to be the payer at $114 per month.
But it sounds like what they're agreeing to right now is different than what's being recommended.
Which was the original support calculation. Based on what has been discussed so far is the interim order that's currently in place, with the exception of summer, which wasn't addressed.
Okay, so we could say then, potentially if the parties adopt the interim order, except that summer will be alternating week to week. Is that what you wish to have?
Yes, sir.
Miss? Is that a yes?
Yes, sorry.
No, that's okay. We just have to get it on the record. So, all right, so let's make it very clear. So if this is ever reviewed, when it comes to the parenting time arrangement, actually the custodial arrangement, this is joint legal, joint physical, you adopt the interim order that has been in place, except that during the summer months, you'll be alternating the child on a week-to-week basis. And once the summer time begins, you start it.
Yes, sir.
Okay, is that your understanding too, Miss?
Yes, because I believe the parenting time actually was the 3 weekends and then the 1 day during the week in the recommendation as well. Which is what we've been doing, but then if there's any nights that he wants to come with me
Sure,
or vice
usual.
versa, we do it.
Okay,
If I may clarify, that was the recommendation for the remainder of the school year.
and you're nodding. Is that the way
Yeah.
you wish to have it,
Yeah,
sir?
I'm sorry, I would like to have it the way we talked, yes, not just the rest of the school year, yes.
yeah, and then during the summer, the weekend is off.
Does it revert back as of the start of the school year would be my question, because that's
Yeah.
not what I recommended.
Okay, is that the case? It reverts back?
Yeah, I'm confused now.
You too. So
Michelle,
after,
do you want to spell it out?
so after summer,
Please.
you're saying there wouldn't be one, or?
So the recommendation was that your interim schedule continue through the end of this school
Yeah.
year.
Okay.
Summer, week to week,
Mhm.
but the recommendation was that week to week continue after you get through summer. So what I've heard so far is that during the school year, you want the first, second, and fourth weekend schedule. But that is not what was
I didn't see that part. in it.
Is that what you wish to have? Okay, who's counsel back there?
Mom, grandma,
I guess.
that's not what they were talking about.
Can I have
all
your
this
name for the
week.
record, please?
Carrie Probst, Kari, Probst, P-R-O-B like boy, S-T.
Okay, we have to iron this out.
Yes.
So you're okay with the school year, with the weekends, the midweek, summertime, week to week, when the summertime begins, father starts it on a week-to-week basis. But then when we go back to the next school year, when the child is back in school, what is it you wish to have? To go back to the previous schedule? Or was it week to week moving forward from there?
Well, we can go back to the previous schedule and then we can come to a compromise beside that.
You can do whatever you wish to, but if you don't agree, we have to have a fallback.
Okay, yes. To continue it, I would like, yes.
To continue what?
To go back when the school starts, to go back to the school.
To the weekends.
Yes.
Okay. Do you have that, Ms. Schultz, so far?
I haven't heard.
Oh, I'm getting there, believe me. I just want to make sure you and I are on the same page. Is that what you agreed to? Yes.
Yeah.
I'm sorry?
Yes.
Okay. Now understand, you could mutually agree to go week on, week off. You could go every day. You could alternate every day if you wanted to, so long as both parties agree.
Mhm.
You understand that?
Yes.
Okay. So Ms. Probst in the back, is that what you understand that they were agreeing to?
No, that it was, the week to week was going to continue from June 1st forever.
Okay.
That's what they had talked about, so.
Whenever one of us, if it's not our time, one of us wants, and we don't ever give each other a problem about it.
Okay. I just want to fall back in the event we
Right,
don't
and
agree.
yeah, that's why I'm okay with it, because he's mutual with it. Whenever he wants to come with me, neither of us say no. We
Okay.
wouldn't ever tell him no.
Okay, so as I understand it then, Ms. Schultz, the school year schedule that parties agreed to, summers, week to week, Dan begins it. Then we go back to the other schedule during the school year. However, if the parties mutually agree to something else, so long as they both agree, that's what happens. Okay. Agreed, miss?
Yes.
Do you believe that arrangement is in the best interest of your child, sir? Yes?
Yes.
Thank you. Did we discuss support?
Briefly, we did. But I have to rerun the calculation based upon the agreement to change the overnights.
Okay.
While I'm doing that, Your Honor, the other part of the recommendation for summer did include that each party would be granted one 14-day period for extended vacations. I don't know if parties wish to include that provision.
We honestly didn't talk about that.
It's in the, like, parenting time.
But what's being proposed is you do get a 2-week block during the summer. Each of you do. You wish to do that, sir? Or do you wish just to go week on, week off?
Either way, it doesn't matter because we can be mutual about it.
Well, in the
It's hard when we just have been agreeing.
in the event you're not mutual, that's the problem.
Yes,
Yeah.
we might as well set that up, yes.
So
Have a 2-week.
each will get the 2-week block during the summer.
Yes, sir.
And you understand, when you exercise that 2-week block, there's a time frame when you have to let the other party know when you want to do that.
Makes sense. Yes, sir.
You understand that?
Yeah.
Miss? Okay, so far? Okay. So we'll go over support here in a moment.
So the, based on going back to the school year schedule, the calculation amount would be Ms. Kazakta paying $278 per month, which does include $7 ordinary medical. But again, the friend of the court has no objection to zero if the parties wish. Uninsured medical would be split with Ms. Kazakta being responsible for 41%, Mr. Kazakta for 59%.
Okay. So based upon what the parties have agreed to so far, if support were ordered, mom would pay support $278 per month, $7 of which, excuse me, would be ordinary medical. Uninsured expenses, medical expenses, mom would pay 41%, father 59%. You understand that, sir?
I understand what you're saying, yes, sir.
But despite that, you wish to deviate and have no support. Is that correct?
Yes, sir.
Okay. You agree with that, miss?
Yes.
Okay. We're getting there. Is it true, sir, that neither party would be awarded spousal support? That issue is forever barred, correct?
Yes, sir.
You've acquired personal property during this marriage, correct? Is that a yes?
Yes, sir.
Has it already been divided?
Yes, sir.
Do you have any property of your spouse, or does she have any property of yours that needs to be exchanged yet?
Yes, sir.
Is that going to be a problem getting that property exchanged?
No, not at all.
Do we need to spell out what property is left, or?
No. It's just small miscellaneous things.
Okay. And you understand that whatever property you hold, if there's debt owing on it, you're responsible for that debt. You forever hold her harmless and indemnify her therefrom. Same for her. If she has property that has debt owing on it, same thing, she'd be solely responsible for the debt and hold you harmless therefrom. Is that your understanding?
Understood. Yeah.
Okay. Are there any debts that need to be divided?
No, sir.
No debts in both names?
No. No.
Good, okay. But you understand that each party be responsible for the debt in their respective names?
Yes, sir.
Do you own any motor vehicles?
Yes, sir.
Cars?
A truck, yes.
How many vehicles?
One.
One? And who has the vehicle?
I do.
And what's supposed to happen with that vehicle?
And we keep driving.
It's not, it was never in both parties.
Yeah, I'm sorry, that's just in my
It's
head.
his.
Okay,
Understood.
so each party would keep their respective vehicle in their respective name.
Yes, sir.
Do you own any land, any home, anything like that?
A home, yes.
And who was awarded the home?
I was.
Is that the house number 156?
Correct.
Is there a mortgage on the home?
Yes, sir.
In whose name?
Mine.
Alone?
Yep.
You understand that being awarded that home, you'll be solely responsible to pay any debt associated with that.
Yes, sir.
Do any of you have, or sir, do you have any, or does she have any pension, annuity, or retirement accounts?
Not with my name on it.
Not with your name on it.
She has them through her work, yes.
Okay.
Yeah.
And would she hold those free and clear from any claim from you? Okay. If either of you carry life insurance that carries cash value, and I'm not talking about a term policy, but these accounts that you invest in, each party would hold that life insurance policy free and clear from any claim of the other, naming a beneficiary of their own choice, correct?
Yes, sir.
Have you discussed tax exemptions?
No, sir.
Okay. I'm not trying to suggest anything, but, well, let me ask this. Are both of you employed?
Yes, sir.
Okay. Is it fair to say then that each of you would alternate the tax exemption from year to year?
Yes, sir.
And you would claim the child in the even numbered years, mother in the odd numbered years? Is that acceptable?
Sure.
Or do you want odd and she gets even? I'm assuming you both claimed the child last year together.
Yeah,
Last year, yes.
Okay. What is it you wish regarding tax exemptions?
To do every other year. I'll start even years.
Okay. Any problem with that, miss? We're near the end of this. Are you aware of any other assets or debts that we've not addressed? And again, the custody and parenting time arrangement for your minor child, you believe is in the child's best interest. Okay, I think I've got it. Ms. Kazetka, please state your full name for the record.
Samantha Gazetta.
Ms. Kazetka, have you heard all the questions and all the answers relative to custody, parenting time, custodial time, property, exemptions, all of that?
Yes,
Is that your understanding of the agreement?
yes,
Do you believe that the custody and parenting time, custodial time arrangement is in the best interest of CSK?
yes.
Are there any other assets or any other debts that you're aware of that we've not addressed?
No,
And do you wish to change your surname?
yes.
And what do you wish to have it changed to?
Probes. PROBSE.
And I have to ask, are you currently expecting?
No,
I have to ask that.
I know.
Because if it's there, we need to address it. All right. And you're satisfied regarding the property settlement that has been entered on the record?
yes,
No one forced you into this?
No.
This is of your own free choice as
Yes.
well? Okay. Based upon the testimony presented, court finds the statutory grounds for divorce have been established, and as a result, an absolute judgment of divorce is granted to the plaintiff, Brandon Kazefka, from the defendant Samantha Kazefka, make a finding regarding CSK that the parties shall have joint legal and joint physical custody. This arrangement is in the best interest of the minor child, based upon the information reached on the record. Neither party shall remove the domicile of the minor child from the state of Michigan without prior approval of the court. Each party is obligated to keep the friend of the court notified of any change of address or employment. Parties are awarded custodial time as outlined on the record. This shows what the help with that, but I appreciate that for preparing the judgment. Neither party is awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning pensions, tax exemptions, life insurance, and standard medical insurance, with the uninsured medical expense divided pursuant to the percentage that was stated on the record. Finally, the defendant is restored the surname of Probst, P-R-O-B-S-T. The judgment has been somewhat started here. I've tried to fill in the appropriate boxes and filled in the appropriate sections. Ms. Schultz will have to review that as well as the uniform support order that will be provided. I wish to thank both parties for being able to agree. Now, what's most important here, and I've said this before, and I'm going to say it again, despite your differences in moving separately, CSK is number one. And the way you're working at it right now is very refreshing to the court, that you are working in that child's best interest. And by doing so, that is going to create a much better environment for the child, because your child, currently 7, absorbs this like a sponge. And that child looks to you for example, looks to you for guidance. And if you provide him that guidance as recommended here, that child will be as much successful as each of you are. So keep that in mind. Regarding the custodial time as well, the court did spell out the default provisions. However, primarily it's by the mutual agreement of the parties. And I failed to mention that on the record, but now we have that covered. So the judgment is in the process of being prepared. It may take a little time, but we'll get that prepared. It'll be executed by the court, and we'll be moving forward. Good luck to both of you. I wish you both the very best.
Thank you.
Move off the way. Parties are present. They both are in pro per or pro se. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Great, thank you. Miss, would you please state your name for the record?
Nikki Sue Thick.
You are the plaintiff in this matter, correct? I'm sorry, I didn't hear you.
Correct.
Thank you. Have you lived in the county of Huron for at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes.
At the time you filed this complaint for divorce, was Mr. Thick also a resident of Huron County?
Yes.
And is it true that you were married on August 19, 2017 in Fort Austin, Michigan by a person authorized to perform marriages in the state?
Correct.
You stopped living together as husband and wife on or about November 11th of last year, correct?
Correct.
Prior to the marriage, Miss, what was your surname?
Sageman.
S-A-G-E-M-A-N?
Correct.
Your husband has always been known as Ryan Leroy Thick, correct?
Correct. It is spelled wrong on the paperwork.
I was going to ask you that.
Yes, it's Leroy, not
Okay.
separated.
It is separate.
It is?
LE space ROI.
So wrong.
Okay. No minor children in this marriage, correct?
Correct.
And you're not currently expecting?
No.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage could be preserved. Was that true at the time you filed the complaint?
Yes.
Still true today?
Yes.
Can you briefly state in your own words why you feel the marriage cannot be preserved?
No longer compatible.
Very well. Any chance of reconciliation?
No.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship?
No.
According to your proposed judgment, neither party would be awarded spousal support. The issue is forever barred, correct?
Correct.
Each party be awarded the personal property currently in their possession, be fully responsible to pay any debt related to that property, with the other party having no claim to it. Is that correct? Has the property already been divided?
Yes.
So you're not holding anything of his, he's not holding anything of yours. Okay. Are there any mutual debts in both names?
No.
but each party be responsible to pay the debt in their respective names, correct? There are motor vehicles, correct?
Correct.
And as I can see here, how many motor vehicles?
There was 3,
How many are there now?
2.
What happens to the third?
I sold my car
Okay,
with his agreements.
okay. So what vehicle do you propose that you will be keeping?
I don't want any of this. We're completely set.
Okay, so you don't have any motor vehicles?
I am going to purchase one after the divorce is all finalized in
Okay,
my own name on my own thing.
but right now you don't.
Correct,
So each party be awarded the motor vehicles currently in their possession,
correct,
and you have none in your possession?
correct.
Okay, got it. Those vehicles, are there any debts owing on them?
Your hand.
No.
They're not in both names, are they?
No.
There is a home though, correct?
Correct.
And I won't mention the street or the address, but the home beginning with 34?
Correct.
And that would be awarded to your husband?
Correct,
And he'd be responsible to pay the mortgage, insurance, taxes, liens, and any other costs or debts associated with that property?
correct,
Is the home in his name alone?
yes,
That makes it easy. Is there a mortgage on it?
yes,
And is it his name alone?
yes,
So he'd be responsible for that mortgage, obviously. Correct?
Correct.
All right. Each party be awarded their respective pension, annuity, or retirement account free and clear from any claim of the other.
correct,
If there's any life insurance carrying cash value, each party would hold that policy free and clear from any claim of the other, naming a beneficiary of their own choice.
correct.
You wish to have your previous name restored or another surname?
Yes, please.
And what name would you?
Sageman.
Sageman? Any other assets or debts that we've not covered?
No.
Great, thank you. Sir, would you please state your name?
Ryan Leroy,
And it's Ryan, L-E space R-O-Y, correct?
yes,
Okay. And it's only L-E.
yes,
Have you heard the testimony regarding the proposed agreement placed on the record here a moment ago?
yes,
Is that your understanding of the agreement?
Yes.
And do you wish to accept it, sir?
yes,
Have you had enough time to consider this agreement?
yes,
Any other marital assets or debts that we've not covered?
no,
Great, thank you. Based upon each of the parties' testimony, court finds that statutory ground for divorce has been established. As a result, an absolute judgment of divorce is granted to Mickey Sue Thick from the defendant Ryan Roy Thick. Make a finding there are no minor children of the parties. Neither parties awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning pensions and life insurance. Plaintiff has restored the surname of Sageman, S-A-G-E-M-A-N. Court has reviewed the proposed judgment and comports with the testimony presented. As a result, the court will be executing the judgment that has been provided. The court has made some modifications to it, specifically regarding surnames, as well as the spelling of Mr. Thick's middle name. And as a result of the court executing the judgment, you'll be able to get copies of your judgment of divorce today. And we, I think, are all set. Ms. Sageman, do you have any questions?
No.
Mr. Thick, do you have any questions?
no,
Good luck to both of you. Parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. Sir, would you please state your full name for the record?
Patrick Charles Dukes.
And you are the plaintiff in this matter, correct?
Yes,
Have you lived in the county of Huron at least 10 days in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
yes,
At the time you filed this complaint for divorce, was Ms. Dukes, your spouse, also a resident of Huron County, Michigan?
yes.
Is it true that you were married, I believe it's June 7th or June 2nd?
Second,
June 2nd, 1984, in Bad Axe, Michigan, by a person authorized to perform marriages in this state?
Yes.
The complaint doesn't indicate when you stopped living together as husband and wife. Are you still residing in the same home together?
Yes.
Okay. Prior to the marriage, your spouse's last name was Koth, K-O-T-H, and you've always been Patrick Charles Dukes, correct?
Yes.
Are there any minor children in this marriage?
No.
As far as you know, is your spouse currently expecting?
No.
You've alleged in your complaint, sir, that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, but there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes.
Still true today, sir?
Yes.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
Just break down.
All right. Any chance of reconciliation?
No.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with the defendant?
No.
According to your proposed judgment, neither party would be awarded spousal support, and that issue is forever barred. Is that correct?
Yes.
Each party be awarded the personal property currently in their possession, be fully responsible to pay any debt related to that property, with the other party having no claim to it. Is that your understanding?
Yes.
Now, you're both living together. Has the property been divided already?
Yes.
Okay. So you're not holding anything of hers, she's not holding anything of yours?
No.
Are there any mutual debts to be divided?
No.
But each party be responsible to pay the debt in their respective name?
Correct.
There are motor vehicles as well?
Yes.
And as I understand it, how many motor vehicles are we talking about, sir?
Oh, what, 5?
Okay. Are they all in your, what, how are they to be divided?
In our, each one is in our own names.
Okay, so each party would keep their respective vehicle in their name and possession, be fully responsible to pay any debt related to that vehicle, the other party having no claim to it.
Yes.
The vehicles, is there any money owing on, or is there a note on any of the vehicles?
No.
Great. There is property as well, land, a home, correct?
Yes.
And I'm not going to go specifically into the location, but the house number is 2556.
Yes.
That be awarded to you free and clear from any claim. Well, wait. It says the property is awarded to you and will be sold within a reasonable time after the judgment is entered.
No sold. I don't know where that came.
Okay. But it's awarded to you.
Yes.
No, are you going to sell it?
No.
Is there any mortgage on the home?
No.
But if there is any debt owing on it, whether it be insurance, taxes, liens, or other costs, that would be your responsibility.
Correct.
Will you remove Ms. Dube's name from the deed?
Yes.
And that'll be through a quick claim deed?
Right.
Okay. Each party will be awarded their respective pension, annuity, or retirement account free and clear from any claim of the other.
Yes.
If there's any life insurance policies carrying cash value, the same thing. Each party would hold that life insurance policy free and clear from any claim of the other, naming a beneficiary of their own choice.
Yes.
Okay, there's another provision here, Mark. Both parties have agreed to split assets as they wish based on their own agreement.
Yes.
Have you reached that agreement already?
Yes.
What is the agreement as you understand it?
As far as,
The property, other than what we've discussed.
oh, this, whatever's her name is hers and mine's mine. I mean, I'm not sure what you're asking.
Okay. No other assets or debts that you're aware of?
No.
Okay. Miss, would you please state your name?
Terry Lynn Dukes.
And Ms. Dubes, did you hear all the questions I've asked as well as the answers regarding the property involved here?
Yes.
Real and personal?
Yes,
Is that your understanding of the agreement?
yes.
And are there any other assets or any other debts that you're aware of that we've not covered?
No.
And you're in agreement with this settlement?
Yes.
No one twisted your arm, correct?
No.
Okay, you made this decision on your own.
Yes.
All right. Do you wish to have your previous name restored or another surname?
No.
Very well. Based upon the testimony, the court finds that statutory grounds for divorce have been established. Therefore, judgment of absolute divorce is granted to the plaintiff, Patrick Charles Dukes, from the defendant, Terry Lynn Dukes. Make a finding there are no minor children of the parties. Neither party is awarded spousal support. The divorce judgment will include the property division outlined on the record, as well as any and all provisions concerning pensions and life insurance. The court has reviewed the proposed judgment, made just a couple of, well, actually just one correction regarding debts. That is, I just added that each party is responsible for paying debts in their respective names moving forward. The court will execute the judgment that has been presented, comports with the testimony presented. And what will happen next, folks, is this file will be taken to the county clerk's office, where Ms. Neal will have it filed, fill out the case number here, and then you'll be able to get copies of your judgments today. Sir, do you have any questions?
No,
Miss, do you have any questions?
No.
I wish you all the very best.
Thank you.
thank you.
You're welcome. Off the record.